Right.
I've known you. I've known you, Diana, for about 15 years on and off, I suppose. You've been very much involved at the European end of the ADR initiatives since 2002, because I think you joined the European Parliament, was it 1999?
1999.
That's right, I have done my homework. And you've been, with your legal background, you very much became involved in the European Parliament's investigation of and encouragement of different forms of dispute resolution processes, to include mediation as part of this collection of ADR processes referred to in the directives. And so you've really been doing that for quite some time, until you left Parliament in 2012, was it? Or thereabouts. And since then, you've been very much involved on I see you're on the board of the IMI, International Mediation Institute, and you are also on the Law Society's EU committee. I wasn't on that. I was on the ADR committee for a number of years, and I always thought it was a poison chalice, but there we are. And also on the board of the European Law Academy. So you come with an excellent pedigree, and I don't think I dare mention your academic credentials, which are ginormous. I know you're a lecturer at Hull University as well, even though it's not on your CV. So any more would do you an injustice. So if you'd like to start by just giving us a bit of an introduction. I think you've got a schedule to go by, and you're going to give us a pause for questions after each section.
That's right. Well, thank you very much, Anthony. And it's really a pleasure to join this. It's a new experience for me doing something like this over the internet, and we'll see how it goes. As you rightly say, mediation in various forms at a European level has always been something of a passion of mine. Although I came to it with a background as a lawyer, it always seemed to me that as we tried to make justice at a European level work, with every country having its own laws and its own legal system, actually an easier way to try to deliver cross-border justice was by using systems of ADR, and particularly mediation. So that was, in a nutshell, the reason why I, in some ways, sort of got involved, because I thought mediation offered a solution to some of the difficulties of traditional legal systems when you're trying to either do cross-border business or to solve disputes. And I think over the last years, most people would agree, in a great measure, the European Union has been something of a driver in terms of supporting and getting mediation more on the map than it was before, certainly through the means of the Mediation Directive, to which we will come back. And as I see the purpose of this evening, it's really to look at the landscape we face after the vote in the UK to leave the European Union, and see if we can make any sense of what might come next. And so what I've done is chosen a few headings, which you should now see on screen, which we will go through. I would like to pause after each one and try to have, if we have questions or discussion, and really see where we go. I mean, if we start with the whole idea of Brexit, I mean, I think none of us really know where we are at the moment. And of course, we have the silly phrase of Brexit means Brexit. But what we do know for the moment is that our country still remains a member of the European Union with all the rights that that entails and with all the duties. So that means that for the moment, the Mediation Directive, the ADR Directive, the ODR regulation, all of these things still continue to apply at the moment. But what we don't know is when that's going to change and in what manner or means that's going to change. We are told that this so-called, well, not so-called, but the Article 50 that triggers the process of beginning the formal negotiations about leaving is likely to be triggered next year, in the first half of next year. It may be at that stage that we will hopefully have a clearer idea of what form the Brexit will take, and that will make it easier perhaps to prepare. But in the meantime, we have really no idea. So we face a period, I would say, of great uncertainty. We can keep going as we are, but maybe as we look at the various elements, there are some things we can try to do by way of preparation for when things become clearer. Of course, there are some people that say that they don't even want to wait for Article 50 to be triggered and that we should just repeal the 1972 European Communities Act, which would just sort of cut us adrift immediately. If that happened, goodness knows what the results would be, because it would mean we would be in breach of all our treaty obligations. So I'm rather discounting that for the moment, but it is a possibility that seems to remain on the table. But having said all of that, it seems to me we are in for a rather acrimonious period, a lot of negotiation, and with that negotiation, uncertainty and possibly discord. We could say it's ideal situation for mediation. Perhaps we should be offering mediation services to the government and to the EU on either side of the discussion as we go forward. But that's where we come in. And as I say, nothing really is certain. And I think we can only go through the possibilities in relation to the bits of legislation that we know. But if anybody wants to talk about Brexit and the process, we can, but I'm not sure that that's the main purpose of tonight.
I've muted everybody at the moment, but I can unmute them, or they can unmute themselves at the bottom right. So if I just stop the share, or wave your hand and I'll unmute you if that's easier. If you have any questions about Brexit. No? No?
Very good. Let's move on to the Mediation Directive, because that, I think, really is what is probably most important from our point of view. The Mediation Directive has been with us since 2008. And as I said earlier, I think in most people's minds, it's been a positive influence in encouraging mediation and providing a good framework for mediation across Europe. It has also had the effect that there has been a huge amount of mediators trained across the continent. And perhaps, you know, we're at a stage where mediation more than ever should be ready to take off. But there was a chance, as with every piece of European legislation, after it's been in force for a period of time, it has to be reviewed. And the review of the directive was completed, in a sense, this summer, with the European Commission publishing its review. I think it didn't surprise many of us that the Commission and you have a European Commission at the moment which is very sort of legislation averse, has more or less decided to do nothing. In other words, to leave the old directive as it is. There were many who had sort of hoped that this might be a watershed where there would be something more done to encourage mediation at a European level. I think that was always unlikely. If any country wants to go forward with some sort of mandatory or quasi-mandatory scheme, that's their prerogative, but not something that was ever likely to be imposed at European level. All the European Commission has said is that there is a lot of room for each of the member state governments to do more to promote and encourage mediation. And that is part of the original directive. There is a, if you like, duty on member states to encourage and promote the use of mediation. And I think the feeling is that more could be done in that regard. But as I say, there will be no new legislation, so it's going to be nothing that is really very strong. There is also some mention in the review that there could be now an appropriate moment to sort of try to set more standards in order to perhaps further professionalise mediation. And the way in which some people had previously been discussing this, and which the Commission has picked up, is by using the European standard setting body known as CEN to do that. Now, I'm a bit, how would I say, sceptical about this, because some of us that investigated this found that CEN has never really done a standard setting exercise for professional service providers. The nearest they get is, I think they did something for chiropractors or somebody in the medical field. So I'm not sure if they would be the appropriate body to produce standards for mediation, and even if they would be interested anyway. But that is just one sort of action point within the review that is there, which the Commission said it was willing to fund. But obviously it is going to take others to get it off the ground to make it happen. Whether it will or not, I don't know. But that's the only sort of, I would say, possible action point that might relate to standard setting in relation to mediation. Other than that, nothing new. In terms of the directive itself and the UK leaving, I think there is one thing that we should also be very acutely aware of, and that is that the Mediation Directive is a so-called justice instrument. It had, in a sense, nothing to do with the internal market. And insofar as civil justice is concerned, the UK has already operated on the basis of an opt-out from the European Union Civil Justice Programme. So I think if we want to sort of try and predict, we could say that because the Mediation Directive is a justice instrument, it's more vulnerable than other policy instruments that are within the internal market. So the likelihood of it continuing to apply if the UK finally leaves the EU, I think is not high. In other words, I think we could lose the directive because it's a justice instrument. It also means that we would lose funding for, which to a certain extent has already gone, funding for participating in EU justice, so mediation training, and perhaps even for our professional providers of mediation training to be able to provide mediation training in other EU countries. So there is a question about funding there as well. But what we would also lose is this pressure from the EU to use mediation. But again, in a sense, we've already left the field. One of the instruments the EU uses to sort of monitor the use of mediation is something called the Justice Scoreboard, and the UK has already refused to participate in that. So I think that already gives you a flavour that we're already sort of absenting ourselves from this area of policy. And that's why I think future application of the Mediation Directive looks fragile. But of course, it may be that in looking at everything, the government would keep what it could or what there was a will to keep in terms of the domestic sort of scenario here at home. But I think what is a worry is that the directive provides a sort of judicial and legal framework, certainly for cross-border mediation, which is its focus. So in terms of suspension of limitation periods, and also with regard to assisting recognition and enforcement of mediated settlements across Europe. And that is a worry if we lose that sort of automatic functioning of those matters. And I think that needs to be watched if there is any way of preserving that. But as I say, that's really with regard to cross-border cases. But of course, we would want to make sure that we had still that facility with regard to limitation periods and enforcement on a domestic level, insofar as it doesn't exist without the directive. So I think...
Sorry, can I just interrupt a second? Sorry, because I'm going to have to go in a minute.
Yeah.
Sorry, I do apologise, but it's just that my understanding is that is not necessarily the case, and that in fact they will have to Parliament will have so much to repeal that it will probably we'll be able to retain the things like the ADR directive and the ODR regulations effectively, because they have been implemented and they have resulted in a reduction in costs for businesses. So my understanding is that in fact I accept it's a risk, but my understanding is that there is a prospect it could continue.
Yeah, Peter, I think I agree with you that they could continue, but they continue in a domestic context only insofar as Europe doesn't agree. Do you see what I mean?
Yeah, I understand what you're saying. Thank you for clarifying that.
So certainly with mediation, I think that's at greater risk than the ADR and the ODR. But the problem is the interface with the rest of Europe, which certainly with ADR and ODR, I really, well, I will come on to that later. But with mediation, if we keep the bits about limitation, etc., for purely a domestic context, that's fine. But we're going to need some sort of agreement with the rest of Europe insofar as there is a cross-border implication.
Thanks very much.
Okay. So are there any other questions about what I've said about the Mediation Directive? As I say, all of this is, it's a bit difficult. We are trying to second guess what might happen.
Yes, they're brilliant. I have those. TK Maxx. Oh, didn't I have them? I get the ones from TK.
Graham?
Yeah, they're brilliant.
Oh, hello, no. I've just come in very, very late, so I haven't picked up. So I won't be. I don't have any questions on that. I'm would like to obviously interested in the ADR.
That's what we're going to come on to next. So you can, of course, correct me because I'm bound to get something.
I'm not going to raise a question just because you've asked me.
Okay, well, let's leave the directive, the mediation directive, for a moment, and let's move on to ADR and ODR. Platform, which went live earlier this year.
Diana, could you just speak the mute? You were mute for a little while there, so if you could just stop.
Okay, can you hear me now? Can you hear me now?
Yes, we can. Yeah, we can hear you.
The ADR directive and the ODR platform came into force earlier this year. And of course, this provides an amazing framework for consumer ADR and a huge impetus for ADR in general, which in a sense has been, I think, a good thing. We can argue perhaps about some of the ways in which it's been enacted in the UK. And of course, with anything very new, there are going to be gremlins in the system and there are going to be problems. But I think what it has done has provided a lot, and will provide, in so long as it's allowed to continue, a lot more awareness amongst ordinary consumers that there are different ways of solving disputes. Of course, mediation is only one of the possibilities on offer. So it doesn't sort of give a huge plug to mediation. And that's perhaps one of the problems, that most of the ADR entities that have tended to be approved to operate in the UK adopt a model that is more in the sort of is more of an ombudsman type process than a mediation process. So in that sense, it perhaps hasn't done as much for sort of classic or traditional mediation as some might have hoped, because of course with consumer claims you tend to be talking about bulk claims or a lot of claims about the similar sorts of issues, and the financial model perhaps doesn't, to be blunt, suit mediation, which is going to take more time and attention to conduct than perhaps an ombudsman type process, on the other hand, might take. So I think it's a plus because, as I say, it's promoted ADR, of which mediation is a part, but perhaps not done as much for mediation as some might have hoped. The other plus side with this, which goes to the question that Peter just raised, is that it is a so-called internal market instrument. It is not a justice instrument. So then we have to think about, well, what type of Brexit are we likely to face? Because if we have a sort of what some people would call a light Brexit, if, for argument's sake, we adopted the Norwegian model, then it's likely that this legislation would remain completely as it is. we would be able to participate also in the ODR platform to solve cross-border consumer disputes. So nothing much would change. But it has to be said that the sort of signals coming out of the government, as much as one can read them, are that we want not to be part of the internal market, but rather that we just want access to it. So it's not clear, again, that this legislation would survive. It could survive, as I just answered Peter, in terms that we would decide to keep it for our own domestic use. And that's a good thing about the directive, that it had domestic application as well. But whether the access to the ODR platform will survive is, to me, something that is up for question, because that is an EU platform operated by the European Commission, and why, if we're not a member and we're not paying to participate in the internal market, should we be allowed to use that? So I think that's what's there to be questioned. But let's suppose that we keep the ADR legislation. I think what we can draw from that is that there is a basic regulatory framework there for ADR entities. Now, there are pros and cons about it. I mean, some people are dissatisfied with the way it's worked. It's a very new piece of legislation. They think that some people have maybe been approved as ADR entities that shouldn't have been approved, and others that wanted to be approved couldn't be approved. So there's clearly room for further work on this, and maybe we can do that at a national level. I think it's also quite good in that it exposes ADR entities and what they're doing to some level of reporting and transparency. And I do hope that would also stay as well. So I think that's the sort of scenario we're faced with here. We have a directive that potentially does good things for ADR. Some of it may survive. It depends on how far we participate in the internal market and how far our government is willing to keep it for domestic use. I hope they do, and I hope we can even make it better. So if I stop there, and I'm sure Graham may have contribution to make, or questions, or others. I can't hear.
Right. Can you hear me now? Can you hear me now?
Yeah.
Okay.
Yeah.
Sorry, I just sent you a text. I'm having great Wi-Fi connectivity issues, only because I'm travelling today, and I've just jumped into a lovely old pub in Malvern, sitting in a corner, but the Wi-Fi is a bit dodgy, so I missed the last 5 minutes. I'm not quite sure whether Peter mentioned an issue we've just raised in an article just written about the other problem with the ADR regulation and the directive, over the fact that in the UK it's simply not being followed, not just by smaller companies or SMEs, which we'd expect because most people don't know about it, it's never been properly published, but by major high street brands. I'm talking about John Lewis, TK Maxx, PC World. They're not doing the simple things, such as carrying the link, first of all, to the platform. And I appreciate, I did hear what you were saying, Dan, about we don't know what will happen as far as online sales is concerned. And on a Brexit, inquiries to a UK-approved provider. But leaving that, the simple thing like carrying the web link, I know from experience I've personally had with my own personal complaints, I'm a great complainer, and many companies just don't even know about the need to do the referrals, even when it's and it seems to me that there's been no effort whatsoever, and from discussions with people in BIS to actually do anything to tell people. Now, so far as the big high street brands are concerned, I don't accept that they are ignorant of these laws, because they will employ staff responsible to monitor consumer legislation. So the big high street brands will know all about this, but they seem to be just ignoring it. And Biz is not doing anything. So I think there's
I think you make a very valid point, Graham, and I saw your article.
making this work.
I saw your article, and I mean, this is part of what worries me. I think there is scope for us to do stuff domestically.
To a limited extent, it is now part of domestic law. And
yeah, but what we're going to lose is the Commission as enforcer, insofar as it could be active, to make sure that some of these things were being done by our own government. So we lose that layer of outside pressure in the future, for sure. And you wonder how high up the list this piece of legislation is going to be in terms of the government acting on it itself. But I think it provides a good framework, but we're going to be left to our own devices, I think.
If I could just cut in there with a sort of, am I on? Can you hear me?
Yes, you are. Everyone's on at the moment.
Yes, certainly in my days sitting in the Law Society's ADR committee, the emphasis was in liaising and persuading the government to expand the use of mediation, particularly in smaller claims. The difficulty is that certainly in recent years, the court small claims service has not been expanded. It's stayed roughly as it was before, with, I don't know, under 20 people manning it. And so at a court level, you've got the limited expertise, but certainly at the ombudsman sort of level, potentially you've got enormous expertise there. Because there's an awful lot of mediators, as Diana was saying earlier on, who are dying to get more experience with mediation. And yet there seems to be this problem of accessing it. Now, we get quite a number of inquiries from people who haven't issued proceedings and therefore nothing to do with the court mediation service. And they are small claims. But these are direct, coming through the government website. But there doesn't... I'd be interested if Peter's still online to hear as to what his experience is with these smaller complaints, and if Greg Hunt is online, what his experiences is with the Ombudsman service.
Right. Can you just repeat the question?
I would be interested. Is that Greg?
Peter.
Peter. Yeah, I'd be interested to hear, because bearing in mind, I was wittering on Peter about the court mediation service being limited to post-issue claims, and there'd be no facility for smaller claims outside perhaps the Ombudsman service. So the referrals we got as an association would come through the HMCSI website. And I would be interested to know what, with Graham and Peter, your experience in the small claims service, bearing in mind you are on the platform, as to what your experience is with smaller claims coming on following the ODR directive.
Well, I do quite a few. But it's normally the trader refusing to mediate. It is the problem. So you'll excuse me, I'm running.
You're running. You can mediate anywhere.
It's normally the trader refusing to mediate. So we have various members, business members, who use our services. We get a lot of complaints through that we deal with for Carpet-Wright and Clarks and others. So, you know, it's quite effective, but a lot of them are building disputes, disputes about cars, and the trader just won't engage. So that's the issue.
I think I mean, certainly at the European level, it is a shame that more pressure can be put on the traders to adhere to the directive. And sorry, Dana.
Well, initially that was going to be the case, but it got watered down in the process. But you know, I think this is what I go back to. I think, you know, if we're going out, we should regard this as an opportunity. You know, you know, I'm passionately pro-European, and I don't want this to happen. But we have an opportunity, you know, within our own country to try and improve this piece of legislation. And I go back to what I said, it provides a framework that we didn't have before that will make more and more consumers aware of the possibilities of ADR. It probably, as Peter has just said, and we all feared, raises expectations that can't be met at the moment. But it hopefully will create a pressure to provide something better. And I think that's what we have to work on. But I think it's sad, you know, it's sad that it perhaps is a disappointment in the way described, but better something, better a start than not at all.
Yeah. It's certainly something that the Civil Mediation Council will be spending some time on in liaising with the trade associations and the Department of Trade.
Yeah. So, are there other questions? Any comments? Or?
Is Greg still on the line?
No, yeah, Greg's here.
Greg, are you there?
Yeah, I'm here. I don't know if you can hear me.
Yeah, we can hear you.
Oh, you're in the car.
In the car, yeah.
What's your experience?
It's similar to everyone else's, really. I think the trader doesn't engage. And I also think I have to be sort of a little bit careful what I say, because I'm not speaking on behalf of any organisation at the moment, is that the price, the cost of ADR for a consumer dispute is too high across the board, and it puts businesses off, puts traders off, and that, you know, until the price comes down, I think they just won't engage.
Do you think?
Of course, when you bring the price down, the neutral doesn't get paid as much, and you don't get as many people prepared to do it. And also maybe you get people prepared to do it until they actually do it. And then they think, oh, I can't be bothered with this. I only get £50 and I've been on the phone with someone for 6 hours. So I think, you know, it's not, until it's enforced, until whether it's BIS or trading standards, whoever it is, actually makes the businesses register with an approved ADR scheme and take part. I just think it's going to be one of the things that people like us will run around for a long time trying to get businesses to engage. We'll be lucky every now and then, but most of the time the business won't.
I think that's a very fair comment. I think a lot of us were always very sceptical that the financial model would work, and I think it's clear that it won't at the moment until business regards it, how can I say, as almost as a compulsory insurance.
If I could just say, sorry, it's Peter again, that the competent authorities are charging too much, so that's why the price is high. So, for example, the CAA, Civil Aviation Authority, wants to charge £15,000 per annum, which is just exorbitant. And then You got CTSI, they charge about 3 or 4 grand. So this is the situation the providers are facing. I mean, I'm considering whether to renew this year, from October, because the amount of work doesn't justify it. So that's what I want to say, really.
Yeah. No, I think this is a huge concern until there is more pressure.
I know that the Chartered Institute of Arbitrators used to do all the ABTA arbitrations at 50 quid a time. It worked well because there was a body of arbitrators, trainee, young arbitrators are quite prepared to do it because it looked good on their CV and everything else. It's not the model you and I and all of us would prefer to see, because we'd like to see it properly funded. But the cheaper version can work if the market's out there for the numbers of mediators willing to do very low value claims at very modest return.
I think Greg had something he wanted to say.
Yeah, just on the ABTA arbitration scheme, I think the fee the arbitrator was paid and the fee that the institute received from the parties was 2 completely different things. There were arbitrators who were prepared to act on a lower fee to get cases, to get experience, to be able to say they've done arbitrations. And of course, a consumer arbitration award is a proper arbitration award. It has to be legally binding, has to stand up to scrutiny if it was to go to the High Court. So they are proper arbitrations. But the fact is they cost a lot more than £50. It's just that the arbitrator only got paid a lower fee. Because it was used largely as a training ground for new arbitrators.
Yeah, exactly. I appreciate that. Thank you.
Right.
Nice picture of Sally up on my screen.
Can you see me? I look a bit dark on my screen.
Shall I move on?
Yeah, what I'll do is I'll just mute everybody and then unmute you, Diana. If you just wait 2 secs, and I'll tell you when you're right. That's you unmuted now, Diana.
The sort of next heading I had was about what I would call our sort of law market in the UK, and particularly, I guess, although I hesitate to say this in Yorkshire, it tends to be London-centred or London-centric. And Anthony said I was on the Law Society's EU committee, and obviously this is one of the biggest preoccupations at the moment about what happens to our whole legal services. And it's not just legal services, of course, we know it's dispute resolution and ADR in its widest sense. Are these services that have sort of been open to the rest of Europe and the world, how are they going to fare as Brexit goes forward? Our professional qualifications, I mean, very basic things, are they still going to be recognised with the same equivalence in the rest of Europe? What is exactly going to happen? Are we still going to have the same sort of market here as we've enjoyed over the last decades? And I think that really is a worry. Because our law, English law, and our courts have a very, very good reputation. And that sort of toes in other forms of work, arbitration, mediation, behind it. And this may all, to some extent, I think, be tied up also with the changes we see at the same time occurring in our own civil justice system. And we've talked about, small claims mediation. we know that the courts are going online in a big way, and I suspect some of you will have seen the sort of report, not only Briggs, but there was a comment or short report produced last week from the Lord Chief Justice about the move online. And interestingly, in relation to civil justice, it sort of very much tends to adopt the language of what we would call a sort of multi-door courthouse. In other words, online people will sort of encounter the court and their claim will be subject to some sort of triage as to whether it's suitable for conciliation, mediation, or the ordinary court process. Now that seems to me that again sort of offers to mediation possibilities in the future that could be quite exciting if done properly, if done with enough funding, etc., etc., all the normal caveats. So whilst on the one hand there may be concerns about what is happening to our legal services in a European context, there maybe is a chance for mediation as the online court in England and Wales comes on stream. And certainly, as far as I know, that's something that I believe the CMC is watching and needs to continue to watch very closely. But of course, at the same time, you've got a growing system in Europe that is trying to offer access to justice online in terms of this huge EU justice portal, which tries to give litigants information about where to go to in a European context. I know they would like to give much more information about mediation services, but also the EU Justice Portal is beginning slowly to take steps to join up, and this will take time, the sort of ODR platform with the European small claims process. So you've got a system, an online system developing in two places, both domestically and at a European level. The European one now seems to be showing some signs of joining up the ordinary court procedure and ADR systems. Our own maybe, but that's again something that I think we have to watch very carefully. I think in terms of a Brexit, we will lose the connectivity, as it were, to the EU Justice Portal, because I go back to what I said, it's a justice instrument, and I can't see how that will survive the type of Brexit that is being talked about, but we will see. The biggest worry, but perhaps a chance in a sense for ADR, is the use of English law and English jurisdiction. Now, I think everybody that's drawing up contracts now needs to be very, very careful about choice of law and jurisdiction. And there's no harm in continuing to plug and champion our law and our jurisdiction. But I would be minded, certainly if I were advising commercial clients, to think very strongly at the moment about arbitration particularly, and probably mediation as well, because the whole sort of European jurisdiction and law architecture may sort of fall apart at some point in this process and have to be rebuilt in a different manner. So we need at the moment to be very careful about choice of law and jurisdiction. And arbitration and mediation can, to some extent, help circumnavigate that. So I think at the moment, there's every reason to promote the use of both of those alternatives and still keep, as it were, dispute resolution legal services in England and Wales. But the problem is, as I say, with regard to jurisdiction, and particularly with regard to our judgments, because if the so-called Brussels I regulation collapses, and almost certainly it will, something else has to be put in its place, and it's not immediately clear what that will be. So a judgment, a UK judgment, may be at risk to not being enforceable elsewhere, and that's clearly something that is a worry in terms of attracting people to use our services. So I think there's some food for thought there, but I also, as I say, see in this period of uncertainty a prospect of actually being able to champion arbitration and mediation to provide something that is slightly more certain outside of the legal systems of the EU in terms of Brussels I on judgments, jurisdiction and enforcement. So I don't know if there are any questions on that aspect.
Sorry, I'll pop back on.
Sounds like Graham.
You're still sitting in your pub?
He's obviously ordering a pint.
Hello?
I think Nancy, you might mute him because he's obviously, yeah, that's it. I just think it takes me back to the 1980s when we were looking at jurisdiction clauses and things like that in the early days of the EU, when I was doing, in those heady days, international arbitration work. And in those days, we tended to go to we chose Swiss law because most European countries regarded Switzerland as so squeaky, neutral, clean, etc. And I think there was then an enormous push towards the London market. But it does worry me a bit that that if for instance, they begin to choose jurisdiction clauses that are particular to the EU in its reform state, excluding English jurisdiction, we might have the same sort of pressure again on the. It doesn't stop the arbitration. I mean, English lawyers being involved, but it might stop, for instance, English mediators and English arbitrators being appointed more. I don't know.
No, I mean, I think you're right. It is. I think the two markets that worry everybody are probably the German market and most likely Netherlands, because they look poised to try to take some of it. And of course, there's Ireland as well because of the language. But really, we have a problem about enforcement of judgments. That's where the uncertainty is. And as I say, that there is also uncertainty if clauses, the architecture appoints jurisdiction, and where we might normally have assumed that we would have it, people will probably, well, they either won't be able to come here or they will choose to avoid it, as you say. And
I'm not really fazed with the enforcement of judgments. Is it the New York Convention or whatever?
The New York Convention is fine, and that's why I think arbitration may enjoy a sort of slight, boom during this period. And although I'd never been a fan of it, of course, there are now moves for this convention on the enforcement of mediated settlements. It always seemed to me somewhat counterintuitive, but if it provides some reassurance, then fair enough.
Yeah, thank you. Anyone else? Nancy, you unmute yourself. I don't know whether you're smiling, Nancy, or saying something. Right.
No, I'm just saying some people have had to go, but they all said thank you very much. They had the other commitments, so they said thank you very much to Diana. And we will have a video of this hopefully on the ANM website, won't we, for the people that kind of dropped in and out.
I think that will be really useful, and thank you, Diana, of course, very much indeed, because it's been very useful. There's a lot of uncertainty there, and I appreciate there's more questions left unanswered than you can possibly answer at this moment in time. But there may be opportunities in all this for domestic legislation to be toughened up and improved, that build up on the directive on ODR and consumer disputes. So it's not all necessarily doom and gloom, but I think it's a matter of keeping the politicians involved.
I mean, I've tried to look at it in a slightly more positive way, to say, look, we've got a decent framework here. We're renowned for our dispute resolution services. Let's try and take the opportunity to make them even better. And especially, as I say, with the developments with the online court, which seem to be properly funded, there is an opportunity. But there's also, I mean, and we can only use the word again, uncertainty, until we know what form this
Well, at least Lord Justice Briggs is married to a very lovely mediator, Beverly Ann Rogers.
We have some good people in good places, yeah.
We do indeed. Well, look, some of you may well be wanting to get dash off and listen to the Archers. In other words, me. So it's been a great pleasure indeed, and so thank you very much indeed, Diana, and thank you, Nancy, for hosting.
And thank you very much, Diana.
Thank you for giving me here.
Okay, bye-bye.
How was the experience, by the way? All right, Diana?
Yeah, it's fine.